All right, good afternoon. Can everyone hear me fine?
Yes, good afternoon.
Okay, welcome to the 5th District Court of Appeal. We have one case on our Zoom docket this afternoon, Christ versus State of Florida, 22-2966. We will
Okay.
at least initially allocate 20 minutes per side. As counsel knows in this case, the court has on its own motion set the argument for today and provided you with a focus order with some questions that we were very much interested in hearing your responses to. But of course, we have time to talk about the case generally as well. I would suggest that the parties, the counsel here for the parties, focus on the focus order to begin with and make sure that you cover those areas that we've asked about. And then we'll try not to get you too far off track, but we probably will have other questions that arise. So, counsel, would you like to reserve any time for rebuttal?
I'll reserve 5 minutes.
Okay, very good. Please proceed.
Happy Constitution Day, first of all. I wanted to get that out. I have your questions, and I believe, well, the appellant asserts in this case that strict scrutiny applies in this case. The requirement that a sexual predator designation be included on a state-issued driver's license imposes significant burdens on the individual, potentially leading to stigmatization and discrimination in everyday activities. And while the state's interest in public safety is compelling, this requirement is not the least restrictive means to achieve this goal. Appellant asserts that less restrictive alternatives such as confidential registry and a discrete code on the driver's license or ID would still provide the necessary information without subjecting Mr. Chris to public shaming.
Ms. Almy, am I pronouncing your name correctly?
Yes.
Ms. Almy, would strict scrutiny apply if the court were to determine that your client has not been compelled to speak, but that rather it was the state of Florida who is speaking?
Are you asking me if this is government speech?
Correct.
I think that it does. Even though it's government speech, it is directed to my client through the Division of Driver's License Services and the statute for him to have this designation on his driver's license, which compels him to speak where he may wish to remain silent. And I think, I'm sorry.
No, go ahead.
I think that the better way to deal with this is like the state of Florida does with sexual offenders, and that is to have the statute emboldened underneath the signature line on the driver's license. And I think that that would cause less of a stigmatization on my client.
So let me fine tune my question just a little bit. If this court were to determine that this is government speech and that Chris is not being compelled to speak, does the First Amendment even apply, or any test they're under strict scrutiny? Would that even apply to government speech?
I think that it does under the Woolley v. Maynard case. That was government speech on a license tag, and it still compelled the Maynards to advertise something that they didn't believe in New Hampshire back in 1977, started in 1969. And that was government speech. And that court, the Supreme Court, held that that was compelled speech and in violation of the First Amendment. So I still believe that strict scrutiny would apply in that case.
If I could follow up, if the government puts up its own billboard along the roadway, pays for it, and puts up some message the government wants to convey, that's what I would call sort of pure government speech. There's no private individual involved. It's the government speaking to the citizenry through a billboard, or perhaps a radio ad or something like that. And I think what your point is here that, yes, it's a governmentally controlled ID. They basically have an interest in it, property interest and so forth. But there's information on it above and beyond what the government would want to convey, but individualized information is well about the individual.
Yes, I mean, it can be identified to him. His name is on there, his address, some of his information, and it can definitely be attributed to him. So I still stick by the fact that this is strict scrutiny, and there has to be, the state has to show that it's the least restrictive means of protecting the public.
Well, there's at least a couple different flavors of strict scrutiny. There's the two case lines we've talked about here where some cases say, yeah, it's strict scrutiny. From what I've seen, all the cases agree it's strict scrutiny. If we get beyond the first step, is it government speech or not? It has some compelled speech aspects and we get to the test. The cases seem to suggest it's strict scrutiny based on Woolley. But some of the cases have some nuances to them. One says that it's a least restrictive means test. Another case says it's a narrowly tailored test. And someone might say, well, what the heck's the difference between those two? Well, I remember in law school, the professor always told me, well, if it's strict scrutiny, it's least restrictive means, that means the state always loses. Okay. But narrowly tailored to me is not quite that strict. It just has to be narrowly tailored. It doesn't have to be the least restrictive means. So can you help us on which aspect that is required in this situation?
That's a lower burden. The government has to show that the designation's reasonable and specific means to achieve the significant interest of public safety without having to prove that no least restrictive alternatives exist. And I just don't believe that applies here at all, because again, branding somebody, this is branded identification with the big letters sexual predator on their license, is not the least restrictive means. And I think, again, if you compare it to what's required in Florida of the sexual offenders, just with the statute number on their license, I would consider that least restrictive. And I don't see how narrowly tailored fits in this scenario at all.
So then did the 11th Circuit Court of Appeals for the federal U.S. 11th Circuit Court of Appeals, did they just miss it on the standard, in your view, in the McClendon case? When they talked about strict scrutiny and they talked about it has to be narrowly tailored, when the sheriff put a yard sign in the soil of an offender's yard, they said strict scrutiny and they said narrowly tailored. Did they just miss it?
I don't know that they missed it. I think it's a little bit different. They put a sign up. They didn't say that these are sexual predators. It's basically just stay away. And they found that under the narrowly tailored test, that was not narrowly tailored to the public safety concern of protecting children from sexual abuse. It didn't have the offender's name. True, their address was, identified because the sign was in front of it, but it didn't pass the narrowly tailored test in that case.
So then if I'm turning back to Woolley v. Maynard, which you cited earlier, and I'll set aside as to whether or not the Woolley court determined that was government speech versus compelled speech. It seems to me that there might be a difference of opinion or view of the Woolley case in that regard. But in the Woolley case, which I have in front of me, and if I'm looking at page 716 of that opinion, that seems to suggest a narrowly tailored test. It says, even were we to credit the state's reasons, and even though the governmental purpose be legitimate and substantial, that purpose cannot be pursued by means that broadly stifle fundamental personal liberties when the end can be, and I'm quoting, more narrowly achieved. So even if this is determined, and I say this for arguendo, even if it's determined that this is compelled speech and not government speech, and therefore it becomes subject to strict scrutiny when it would not be subject to such scrutiny if it was governmental speech, would not Woolley and McClendon and other cases from around the country that have dealt with this suggest that narrowly tailored is the proper test?
I would disagree with you on that. I mean, I read Woolley v. Maynard. I have it here, and throughout the case, it talks about strict scrutiny. It might be mentioning narrowly tailored in the opinion, but they come down to the fact that it is the strict scrutiny test, and that making the Maynards have this live free or die credo on their license is not the least restrictive means. And I think ultimately they were able to either cover it up or get a license that didn't have that message on it.
Let me ask you a factual question. In Florida, you can get an ID card as well. And I'm assuming that if you're a sexual predator, whether you get a driver's license or an ID card, or perhaps you can get both, no matter the situation, the sexual predator designation would be on either of those cards.
Correct.
Okay. And there's no such thing as a sexual predator ID in Florida. In other words, there's no ID card that sexual predators have to hold separate and apart from everybody else.
No, I think the Florida ID, if you've ever seen one, looks exactly like a license, but it specifies it's a Florida ID. And I think the statute would be the least restrictive means to protect
and that leads into the second question in our focus order, which is, what are we to do? Are we supposed to say, okay, they had a couple ways of putting this designation on a driver's license or ID card? They could have used the words, they could have used the statute, I'm not sure, maybe a symbol or something else. Are we, as the judicial branch, are we supposed to look at the designation compared to what other designations they could have used on the card? Or are we to look at the designation and say, wait a minute, there's already a registry out there. If someone wants to know someone's a sexual predator, they can put it into the database, they can find out where the person lives, they can look at the person's record and all that. So there's registration requirements, there's the database, public database, and so forth. We're supposed to say, hey, look at what all this information the government is providing to people to protect themselves and have awareness of sexual predators. Is this a step too far to require the driver's license in the context of everything else? So is it a micro view of just the card, or is it a bigger view of all the things that Florida does to prevent recidivism?
I think all of those are important. I think the registry is important. The public domain is important. I don't think those are substitutes for putting something on a driver's license. I do think there is a public interest in keeping the public safe, as well as notifying law enforcement. So I think you can still have something on the driver's license that would be constitutional, and you could have all of these other safeguards. I don't think it's one or the other.
This Almi, I've got I'm struggling with, and I think this kind of dovetails onto what Judge Makar was asking, but I guess I have an overall, I don't know if it's a 20,000 foot view of the case, but I just want to know, is it the fact that this text appears on a driver's license, which is government property? I believe you would agree with me on that in the state of Florida. It's not personal property. Is that what makes it speech that's protected?
It's protected speech because these words, sexual predator, on a license or an ID with a picture of this man and other sexual predators, and their identifying.
Let me ask you a follow-up question. If my driver's license says organ donor on it, is that protected speech?
I don't think so, because that's not a stigma. That's not, you wouldn't walk into Publix and have to show your driver's license to get alcohol, for instance, or Sudafed, or all the things that they make you use your license for, and have people judge you on that or look at you funny, or, you know.
Well, what if somebody doesn't have organ donor on their license compared to somebody who does? Is that speech?
I don't see it as that. I think
so. It's basically what I'm gathering from your. Maybe I'm reading into the answering of the questions based upon whether or not the label attached that's put on the license, and disregarding the fact that it's maybe factual, like your client was at some point in the past factually found to be labeled as, pursuant to Florida law, as a sexual predator, which your client could have challenged that finding in court prior to it going on the license by operation of statute. It's whether or not the label is harmful to the person who has the license titled in their name. That's what makes it speech or protected speech based upon your argument. Am I understanding you correctly?
Yes. Yes, it identifies him as a sexual predator.
but it's specifically because it is a negative connotation or a negative label that you are saying raises it to that level of protected speech.
I think it goes beyond just being negative. It stops, well, first of all, you're the one that asked to be the organ donor. You were the one who asked that that be put on. This is, like you said, it's being directed by the government. But what the sexual predator designation on these licenses does is it stops people from getting a place to live. If they want to rent, it stops people from being able to get a job, because now when you get a job, you have to show your driver's license and your social security card. So it impacts them negatively.
Well, it doesn't, with all due respect, it does not prohibit them from it. It just limits the parameters by which they can obtain employment or residence, or it just restricts certain behaviors that they're restricted from doing, correct? It doesn't prohibit them from doing this. It just attaches certain parameters on their conduct.
Yes. And there's a lot of sexual predators living under bridges in the state because of these laws. So again, I would say that it's strict scrutiny and there are less restrictive means, and this is not a least restrictive, solution for this. Also, I have a yellow light. Does that mean what does that mean?
Yeah, you reserve 5 minutes, correct?
Okay, yes, I did.
So you're into your rebuttal time.
Okay.
Stop.
I would like to stop then.
Okay, great. Thank you.
Okay.
May it please the court. My name is Richard Pallas. I represent the state of Florida. Here, our argument is simply that the Florida Sexual Predators Act is not unconstitutional, and under any form of scrutiny, whether strict, intermediate, or rational basis, this would meet any of those parameters listed within those particular theories.
Is this sexual predator designation on that driver's license, which Florida statutes defines as a certificate issued by the Department of Highway Safety and Motor Vehicles, is that statement, sexual predator, government speech, or is it compelled speech by an individual?
Your Honor, while of course the cases coming out of Alabama as well as Louisiana seem to state that this kind of this would be compelled speech, the state, while it did not argue this in its answer brief, would certainly agree that this should not be considered compelled speech, and this should instead be just government speech and not be privy to the strict scrutiny analysis. That all being said, all of those cases take that four-prong test as to whether it's speech, whether they disagree with it. Although that being said, as this being a statement of fact, and a fact that cannot at all be, how would I say, circumvented because of the fact that nothing changes that these defendants are sexual predators, I would argue perhaps while these cases have relaxed the disagreement with the content or whatever the speech is, I certainly would agree that this could be government speech and not privy to that strict scrutiny analysis, Your Honor.
So the two cases you're referencing are a federal judge in the Middle District of Alabama and the Louisiana Supreme Court in 2020, right?
That is correct, Your Honor.
No other court. No other court.
There are no other courts that have so far not at all actually considered the sexual predator designation, only the sex offender designation. That is correct, Your Honor.
But in the terms of whether or not it's government speech or whether or not it's individual speech, the two cases you cite that consider it compelled speech, that is the Middle District of Alabama, and that's the Louisiana Supreme Court, which are the two primary cases relied upon in the initial brief of the appellant, right?
Yes, Your Honor.
So let me ask you this: if you were to go back to Woolley versus Maynard, the live free or die motto, the speech did not occur for the individual by his possession of the license plate. The speech occurred, and you correct me if you have a different read, the speech was compelled when the law required him to attach that plate to his personal private property, i.e. his vehicle. That's when it triggered compelled speech under Woolley v. Maynard. Do you read it differently?
I believe that's the correct way to read it, Your Honor, because...
Is that not how McClendon read it? Precisely as I just described it?
Yes, Your Honor. The way that I saw that Woolley was necessarily read is with Woolley, you had an ideological message, but it was a crime to cover up that message and them requiring you to attach that license plate and criminalizing the covering of that was, I believe, where Woolley was implicated.
Well, Woolley, let's talk about Woolley for a minute because it seems to me Woolley is a classic compelled speech situation. It was a license tag on a car and so forth. A driver's license, let's say it's governmentally owned, you would concede just because it's governmentally owned, in other words, the property interest in the license, that doesn't take it outside the compelled speech doctrine itself, does it?
Certainly, Your Honor. Certain speech, as interpreted by the cases, while government speech can still be considered compelled speech.
Right, because I mean, the example I gave initially was the government puts up a billboard, they rent it, they put up their own message alongside the highway or whatever, right? That's pure government speech. You would agree?
Yes.
Okay. Now, when they start adding things to it or putting the message and other data and other information on a license tag or a driver's license and so forth, it becomes sort of a hybrid. It isn't just pure governmental speech, and that's why the compelled speech doctrine applies, correct?
At a certain point, yes, Your Honor. Obviously, with Woolley, we were limited to just ideological speech, but of course, the United States Supreme Court has slowly opened that analysis to other types of speech beyond.
I mean, in the extreme, if the government said, okay, sexual predators, here's your sexual predator T-shirt, we own it, we control it, and you have to wear it. That's going to be compelled speech, right?
At that point, a T-shirt with that particular monitor on it, if owned by them, that is something that is, well, of course, bonded to their actual body at that point, Your Honor. So I would see that being compelled versus a license plate or a driver's license, which is not always visible.
Well, a driver's license is different from a license plate. Someone may not know that's my car, right? But everyone knows this is my driver's license when I present it, correct?
That is correct. Well, unless, of course, one is presenting a forgery. But in this case, I wouldn't imagine anyone showing a driver's license that's a sexual predator when they're not a sexual predator.
Right, right. So on the focus order, if we assume it's at least hybrid speech of some sort, and the compelled speech doctrine applies, have the test. The cases have all set at strict scrutiny to date. The nuance was this narrowly tailored versus least restrictive means, and then what do we look at? What do you have to say in response to that part of the focus order?
Well, yes, sir. For the first part of the focus order, Your Honor, what we're dealing with here is I would certainly argue that if you had to apply strict scrutiny, assuming this is a hybrid government compelled speech, is that we would certainly assert that the narrowly tailored would apply instead of the least restrictive means. That being said, some of these cases have mentioned both of them in tandem with one another. As I recall reading some of these, I believe McGuire, the most recent Alabama District Court case, which denied or entered summary judgment for the law enforcement defendants. That one cited to the Williams-Ulay versus Florida Bar case, which had obviously come out in 2015 in the United States Supreme Court. And in that one, they used them in the exact same sentence. I believe they stated the state's compelling interest through the least restrictive means was not narrowly tailored, was their particular argument by the challenger of Florida's canons regarding how one can solicit donations and the like to judicial campaigns.
But Williams versus Ulay, I think it's almost, except for perhaps Justice Breyer, almost every opinion talks about narrowly tailored. Justice Scalia's dissent, joined by Justice Thomas, Justice Kennedy's dissent, Justice Alito's dissent, and Chief Justice Roberts' majority opinion for the court. They all talk about narrowly tailored in that case.
Yes, Your Honor. Narrowly tailored is mentioned in Williams-Ulay.
Let me ask you a question. Let me ask you a question, and I may
Yes,
invite Ms. Almy to address this in her rebuttal, because and maybe it's just a grammatical curiosity for me. How can the least restrictive means test apply if the challenged statute does not restrict either act or conduct, act or speech? How could, when the statute doesn't restrain or restrict something, how could the least restrictive means test apply?
Certainly, if there is no restriction, Your Honor, I could see that that test would then not apply. I know other cases have synonymously or differentiated with least intrusive means at that point, but you could argue the same way. It's not an intrusion versus a restriction in the event that as you have mentioned, Your Honor, we are not actually restricting someone from doing anything. Of course, here we have our statute under criminalizing the alteration or not displaying this on your particular driver's license, but that's just a crime based on the status that this particular defendant and similarly situated defendants are. They're sexual predators. It is a crime.
Aren't you restricting under penalty of criminal penalty to you having, if you're a sexual predator, to having to show this information?
It is required, yes, Your Honor. That is reflected both in the driver's license requirement within 48 hours, which is within the text of the Florida Sexual Predators Act. It is mentioned in the other two statutes that are being challenged here. One of which being that one must get this driver's license and the other criminalizing the alteration or failure to display this phrase on that driver's license.
Right. So the restriction is that you can't just have a license without this information. You have to have it. If you don't, it's a criminal penalty.
That is correct, Your Honor. In this, there's a criminal penalty, and that is how you are restricted. You are not allowed to get a driver's license without this. In fact, you must get this driver's license. That is at least as required by these three statutes.
So the two questions under the focus order. If it's a narrowly tailored test, how do you prevail, have the statute upheld when there's this alternative that says you can just put the statute number in?
Well, Your Honor, here, instead of dealing with the sexual offenders, which is a much broader form of conduct, here we're dealing with far more reprehensible, more heinous, more dangerous to the public crimes. And unlike these particular sexual offender statutes that have been challenged in both Louisiana as well in Alabama, in those we didn't have this heightened gravity of, how would I say, the seriousness of those crimes. There's a higher gravity of risk attached with a sexual predator than there is with a sexual offender. And in this particular circumstance, to say, we'll just put the statute on it, law enforcement can be alerted. That runs with Doe 1 in Alabama, and it'll certainly run with State v. Hill with Louisiana. But in the State v. Hill with Louisiana, we didn't have a consideration of increased risk of recidivism, if you will. Or I'm sorry, that is actually restricted to McClendon, the 11th Circuit case. With State v. Hill, instead, what we're dealing with is, again, just sexual offenders versus predators. What is required here, at least under the Riley versus National Federation of the Blind, we need minimalism, not maximalism. But minimalism requires us to actually get the, at least as stated in Woolley, the same basic purpose. Our basic purpose here is to protect the public. And we can't say that every single person is going to understand who should be protected by this particular sexual predator statute, that they would understand what SP means in red letters, or what the statute 775.21 would mean. In those particular circumstances, say you're a grocery clerk working alone at your store, you're a hotel clerk alone, and someone checks in, you see their license plate, you know that they are a sexual predator, you're a member of the public meant to be protected by this. Say your kid is with you at that hotel. That is also someone who has heightened protection under these statutes. And there's the possibility these people working in these public jobs that are not at school districts that might have registries, or at law enforcement offices that have these registries. If these people are going to fall through the cracks, we haven't met the minimum requirements to achieve the same basic purpose as stated in Woolley back when we were only covering ideological speech before this was raised to additional facts.
You would agree, would you not, that Williams versus Yulee, as quoted by McClendon, says narrowly tailored does not mean perfectly tailored, right?
That is correct, Your Honor.
In other words, so even if a court were to conclude that there's a more narrowly tailored approach, perhaps that's a prerogative left to the legislature, because narrowly tailored does not mean it has to be perfectly tailored or perfectly tailored to minimize whatever shame or embarrassment has been asserted by the appellant. Is that a correct understanding?
That is a correct understanding, Your Honor, because while one could argue that it would be more narrowly tailored here, or it would be least restrictive under whichever theory, that one could give training to everyone at school districts, everyone working at parks and recreation, any of these places where sexual predators are not meant to be. Can we say that it's worth letting these potential victims fall through the cracks and say, well, you didn't attend the training to know what this statute means? And by all accounts, if we train everyone in the entire state of Florida to know what that statute means, we've essentially alleviated the fact that we're not saying sexual predator. Everyone knows what it means at that point. And so I don't believe going into something further, like saying we're going to train people to know what a symbol means, is the means that we should go to. As you said, Your Honor, it's not perfectly tailored, and I think it's important that we still meet the minimum threshold here, and that is protecting.
And I don't mean to, I don't mean to be nitpicky with you. I did not say it wasn't perfectly tailored. I said the case precedent from the U.S. Supreme Court doesn't require it be perfectly tailored.
That is correct, Your Honor.
Okay, because I'm not commenting on whether or not this is tailored, perfectly tailored, narrowly tailored, or even if it has to be tailored. I'm just trying to understand the precedent being brought forward.
Yes, Your Honor. Of course,
and it's a precedent involving a different form of speech. It's not what we have here necessarily. It's a form of compelled speech, but different. Let me ask you a quick question, because you're taking the position under the narrowly tailored approach, you win. But wouldn't someone ask and say, well, what could you do that's even more restrictive or more harsh than put it in bold letters on a license? Is there something beyond that? Maybe the T-shirt example I gave, I don't know, but
I would argue the T-shirt example, a holographic beacon floating above the particular sexual predator's head stating who they are, a sign on their lawn, the size of a billboard, and them being compelled to do so.
Let's limit it to the license then. I mean, I'm sorry I threw the T-shirt example, but what more could you do on the license context than what the state of Florida has done?
It could, of course, be larger. They could put it across diagonally instead of in the small letters that we particularly choose to put on in this. Not that much bigger than our organ donor designations that will go on our licenses. With the driver's license itself, we could put it in all four corners so that I might have missed it looking over here because I was looking for your birth date, or I was looking to make sure your name matched up with the check you're writing. But if you have it going all along the borders of it with a driver's license, that's how we would, of course, get more intrusive, if we're dealing with intrusive factors.
I don't know that you addressed the last question, which is, are we, as a judicial branch, are we supposed to be looking at the record here, which is pretty slim in many ways? Are we supposed to be looking at the record and say, okay, look at all the ways Florida protects the public and provides police officers with information through databases, registry, and so on and so forth? Should we look at all that information and then say this restriction goes too far, or we're supposed to just look in discrete at the license, information on the license itself?
Certainly here, Your Honor, what is important here, at least in our governmental interest that is codified in the Sexual Predators Act, is the fact that we're alerting the public. This is about registration of this defendant. It is also about warning the public that this particular person is a sexual predator. I think that when we're looking at whether we're doing least intrusive means or alternatively narrowly tailored, I believe those are still factors to consider here. Registry, also whether or not there are notifications that go out, but not everyone may have a cell phone that receives those notifications. Not everyone may go into the sheriff's office, may access the sheriff's site. Not everyone may have the access to these lists of everyone who's a sexual predator, and might not have the memory to support what that person looks like, their height, weight, age, and of course, just their appearance on the button. We need to give them just another chance to know that they're dealing with a sexual predator, because there may be some people who just simply would like to know that they're dealing with one, especially with all the crimes that are implicated by this, whether human trafficking, in addition to all the child sex related crimes. there's the possibility that people who are alone in certain circumstances who are checking your ID need to be warned of this. I think that if we look at this and there's too many ways that someone can fall through the cracks and not be alerted, I think that that's the stronger factor in this. Just having a registration or a registry and having a notification system alone won't be enough. Again, going all the way back to Woolley, it's about the same basic purpose here. And I don't think we meet the same basic purpose without something further than notification and registration. Changing this to a code or initials is going to potentially confuse the public. And again, may infringe upon what the legislator mandated by the public put together here in trying to make sure the public is protected from these particular defendants.
What if there was a barcode put on the driver's license and it got scanned into the internet and the person's whole criminal history pops up? Let's say Florida required that.
If Florida requiring such a thing as that, I could see them going with the QR codes that are now popular at your grocery stores or other things where your cell phone's camera can convert that to you. But what if someone doesn't have a working scanner, Your Honor, or they don't happen to have a phone that can read QR codes to scan that particular barcode? It's every single person that comes by. If I know to scan a barcode, I may already know there's something that's a problem with this person, and they may very well be a sexual predator anyhow.
And it's a policy question. The legislature has made some pretty strong statements in the statute about the legislative interest here and protecting the public. So it seems to me that that's certainly on the state side that there's an important public interest here to be protected. Correct?
Yes, Your Honor. We have a very important public interest here. I would say it's an overwhelmingly compelling interest versus what the Louisiana as well as the Alabama cases had with just their respective sex offender statutes.
But even they acknowledge the compelling interest. Nobody has ever questioned the compelling nature of the interest.
That is correct. There's no question that this is a compelling interest, and certainly the defense has also conceded as much. This is definitely a compelling interest, and I believe that this achieves that same basic purpose. This is the minimum, at very minimum, that we should be observing in order to protect the public from these particular individuals.
Well, and as a policy matter, the legislature could say we're going to put DUI on people's licenses or vehicular homicide, or there's any range of offenses that can be put on a license. But here in Florida, this is the one that they focused upon and provided legislative findings in the statute.
And certainly pre-Riley, United States Supreme Court ruling, this particular DCA has ruled that having convicted DUI it was legal and was not compelled speech. That being said, that was post-Woolley, pre-Riley. We still have precedent from this court saying that convicted DUI on your license plate or as a bumper sticker, I believe, was all right. And I think that it's not a problem to have this. This is whether least intrusive, least restrictive means or narrowly tailored, or certainly under our lower forms of scrutiny. I believe that this meets any of those tests. I see that I have gone over my time, but if this court has no other questions, I will rely on my brief, and I ask that you affirm.
Thank you, counsel.
Rest on my brief, and I would ask you to overturn this.
Okay, you're waiving your time?
Yes.
Okay, I was going to give you an extra minute, but that's fine. If you want to waive the 4 minutes, that's fine.
Yes.
All right, well, I want to thank both of you. When you got the notice in the mail that we're going to have oral argument, I'm sure that was a bit of a surprise, and I'm glad you have prepared so well for it today, and we very much appreciate it. This is a challenging case and one we really, I think, have benefited greatly from your advocacy today. So with that, we will stand adjourned.
Thank you, Your Honor.